Austin. Okay. Senate Committee on State Affairs will come to order. Clerk, call the roll. Yeah, call the roll. That's good.
Present.
1661. Oh, no, Austin's on a search.
Here.
Here. 5 present. Members, we're going to start with Senator Nichols. You're recognized on House Bill 1661.
Thank you, Madam Chairman and members. Currently, the election code allows for the withdrawal of a candidate for political office within the 57th day before the election day. However, if a candidate decides to withdraw after the prescribed time, the candidate's name still appears on the ballot despite withdrawal, even if ballots have not yet been printed. 1661 amends the election code to allow a candidate to sign a waiver after an untimely withdrawal, allowing for the omission of the candidate's name from the ballot only if the ballots have not yet been prepared. That is what the bill does. This actually happened in my district. I had a school election. They had not printed the ballots. There were 2. We were past the 57 days. 1 dropped out. They hadn't printed the ballots, but they were forced to, because of current law, to do that. And so that little school district had to pay $15,000 to print ballots when that's it. This is not mandatory. This says they may choose to omit the candidate if they meet this. All right. Thank you.
Take your time. I was putting thumbs up to my staff who found my purse with my glasses.
Oh, I thought you were going thumbs up on me. I thought you were going thumbs up. I think you will have. Yeah, I get the message. That was time to quit talking. You probably, I understand that there may be somebody here actually opposing this.
Yes, there actually is, so we'll hear why he doesn't like it. But with that, any questions of Senator Nichols? Yes, Senator Zaffarini, you're recognized.
There was a situation I'm aware of where a candidate announced that he was withdrawing from the race, but then didn't. He didn't have his name removed from the ballot. So while he announced he had withdrawn, he did not remove his name from the ballot, and then at the last minute, he had full-color newspaper ads and other TV and radio appearances. This wouldn't cover that situation, would it? The situation where someone announces he's withdrawn, but...
No, I'm talking about he's actually required to do a, kind of like an affidavit, and it's spelled out in here.
But it wouldn't cover that situation then, would it? Where someone just announces...
No, he or she would actually have to sign a waiver and present it, and that procedure's in here. And if they do that and the ballots have not been printed, then the local entity, it gives them the option to not print it. Had this bill passed, my little school district would have $15,000 more right now.
I like it. I'd like to also cover the other situation, though. I guess it's too late to do that this time, though. Thank you.
All right, we will open public testimony on House Bill 1661. We do have Keith Ingram as a resource witness if you have any further questions. Ed Johnson for Harris County Clerk's Office is against. We'll hear why he doesn't like it. Thank you. Good morning, Ed. Do you live up here now? Because you're here.
Just about, I tell you.
You're here every hearing.
Ed Johnson with the Harris County Clerk's Office. I think there was a change from when the House version that made it to a May. So
but you speak into the microphone. Make sure it's on.
Speak into the mic.
There you go.
Okay. It's where's? That's it. Is it on? Okay, great.
Yeah, we can.
Ed Johnson, Harris County Clerk's Office. I would like to change mine to on the bill, if you can. The May that's been added in there, evidently from when it was heard in the House, makes it more palatable for us. If we're not required to do this. Really, what would be great for running elections is before you print the ballot, there's about a month's worth of work that goes in Harris County into producing a ballot, doing the LNA test, doing the ballot proofing, all that before we actually print it. So if you were to withdraw a name right before you print it, you're going to have to back up and do that month's worth of work over again. You have to rerun the LNA test. So a better definition of when this deadline would be great in the law, so that you could understand, if it was before you started your LNA test, I think would be more appropriate on there. Okay.
And I would state most likely in an area like Houston, where you have that much population, you don't really have many uncontested races, but in small rural communities, it's quite often. So, thank you.
Good morning, Madam Chair and members. Under current law, the state election code allows an election official to accept an absentee mail ballot only until 7 p.m. on Election Day. Oftentimes, voters who choose to vote through the mail rather than a physical location on Election Day do not get their votes counted at no fault of their own. It's generally just a postal delivery service issue because you can obviously have a premium for a one-day service or a standard multi-day delivery. The committee substitute, Madam Chair, and I think we'll ask for a committee substitute to be brought up at this time.
Committee substitute to House Bill 1151.
Committee substitute seeks to address this problem by providing an opportunity for eligible voters who mail their ballots in a timely manner, which would be having a postmark or an indication that it was mailed before 7 o'clock on Election Day to be counted up till 5 p.m. the day after Election Day. Of course, the election officials are busy counting provisional ballots and other things under statute right now, so this wouldn't be any extra imposition. I think that we have the version of the three amigos here on all sides to testify in favor of this, so I would ask for your consideration of the bill.
And any questions? No? Okay, we'll open public testimony on House Bill. Okay, and I understand the
by the way,
committee sub was in the House, right? So
Right,
we're
Madam
not-
Chair,
we
right.
didn't
Sorry,
send
there's
up
no
one.
substitute. My apologies.
No problem. All right. We have Keith Ingram as a resource witness from the Secretary of State, and Ed Johnson for the bill. You can come on up. And Ed, no one's opposing this, so let's just...
All right. Ed Johnson, Harris County Clerk's Office. We're for the bill. It would help voters.
Thanks. All good. All right. Close public testimony on House Bill 1151. We'll leave that pending till we have a quorum. And who's next? Senator Buckingham. Recognized on House Bill 24-7. Oh, did you have another one, Paul?
No, just one this morning, unlike yesterday morning. So
Okay, good. Thanks for being here.
Right.
All right.
Thank you, ma'am.
Senator Buckingham, you're recognized on House Bill 2471. 2471? Is that wrong? It's 65?
I have 1379 and 2465, but we can.
Okay, just start with 1379. We'll figure it out. What happened to this one? Oh, okay.
Thank you, Madam Chair, members. Under current
got it.
statute, both general-purpose political committees and out-of-state political committees that have appointed a campaign treasurer are required to notify campaigns that are the beneficiary of their direct campaign expenditures. Out-of-state PACs that have not appointed a campaign treasurer are not subject to this notification requirement. House Bill 1379 aligns notification requirements of these out-of-state PACs to be consistent with general-purpose PACs and out-of-state PACs that have appointed a campaign treasurer. The bill requires outside PACs that make direct campaign expenditures to notify the benefiting candidate or office holder of their doing so. The bill also clarifies that outside PACs that make certain direct campaign expenditures must disclose their financial statement with the Texas Ethics Commission. This bill was passed 137 to 7 out of the House, and with that, I'm happy to answer any questions.
Any questions of Senator Buckingham? Okay, do we have cards? No, anyone want to testify on, for, or against House Bill 1379? All right, close public testimony. 24. What's about that one, no? Okay. It lays out House Bill 2465. Do you have that one? Yes, okay.
Thank you, Madam Chairman. Members, House Bill 2465 removes confusion for corporations and labor unions seeking to comply with the law and prevents future litigation from being brought against the Texas Ethics Commission. This bill codifies a 2013 U.S. Circuit Court of Appeals for the Fifth Circuit decision that held corporations and labor organizations may make political contributions and expenditures to certain political committees that make only direct campaign expenditures that are independent of any political campaign. It was filed based on a recommendation included in the Texas Ethics Commission 2016 report to the Legislature. The bill amends current statute to clarify that corporations and labor unions may make contributions to PACs that only make direct campaign expenditures. It also clarifies that these PACs can make contributions to other PACs that make direct campaign expenditures, but not to PACs that make political contributions to candidates, office holders, and specific purpose PACs. This bill passed 144 to 1 in the House, and with that, I'm happy to answer any questions.
All right. Any questions of Senator Buckingham? Anyone want to testify on, for, or against the bill? Public testimony is closed. Thank you. All right, Senator Burton, you are recognized on House Bill 214.
Great. Thank you, Madam Chair and members. I do have a committee substitute I'd like to introduce.
All right, Senator Birdwell sends up the committee substitute to House Bill 214.
Texas Supreme Court is the highest court of civil matters in Texas, while the Court of Criminal Appeals is the highest for criminal matters. Since 2007, the Texas Supreme Court has recorded all of its oral arguments and archived them online. Currently, the Court of Criminal Appeals does not make video recordings of its proceedings. While the Court of Criminal Appeals does not have video recordings, they do make audio recordings available for $5 per oral argument. But this is not easy to find on the Court of Criminal Appeals website. More than half of the nation's high courts are already making video recordings of oral arguments available online. This bill would improve transparency by allowing the public to view the court's arguments and evaluate the efficacy of the judicial system, while allowing for greater awareness of the court and its proceedings. The committee substitute contains the Ogden Fiscal Responsibility Amendment. Thank you, Madam Chair and committee members.
All right, any questions of Senator Burton? All right, no. We'll open public testimony on House Bill 214. We just have one person registering a position in support, Dennis Baggett from the Texas Press Association, in support of the bill. Does anyone else want to testify on, for, or against House Bill 214? Close public testimony. Senator Burton, you are recognized on House Bill 1904. That looks fine.
Thank you, Madam Chair, members of the committee. This bill amends certain sections of Chapter 54, Subchapter H of the Government Code affecting Tarrant County to grant explicit authorization for certain referrals, powers, and duties not currently provided in statute, as well as modify the ability of Tarrant County to compensate magistrates, providing for the part-time employment of criminal law magistrates. New powers granted to criminal law magistrates under this proposal include the ability to discharge certain routine motions and oversee specialty court proceedings. These changes will allow Tarrant County to better manage their criminal case dockets. The Senate companion to HB 1904 was voted out of state affairs unanimously earlier this session and passed out of our chamber 31-0. Thank you, Madam Chair and committee members.
All right, any questions of Senator Burton? No cards. Anyone want to testify on, for, or against House Bill 1904? Close public testimony. Leave that pending. Senator Burton, you're recognized on House Bill 2886.
Thank you, Madam Chair. Members, currently Section 81091 of the Texas Health and Safety Code requires a physician, nurse, midwife, or other person attending a birth to apply an antibiotic ointment to a newborn's eyes. Failures to do so is a Class B misdemeanor punishable by confinement in jail, a fine, or both. The antibiotic ointment prevents ophthalmia neonatorum and associated complications such as blindness that may arise in the newborn through a birth to a mother with certain untreated or undiagnosed sexually transmitted infections. Currently, a parent's objection to the administration of this ointment puts the healthcare provider at risk of criminal prosecution. HB 2886 protects healthcare providers in these situations by specifying that a provider attending a childbirth does not commit an offense under this section and is not subject to criminal, civil, or administrative liability or any professional disciplinary action for failure to administer the ointment due to a parent's objection. The provider must document this objection in the newborn's medical record. The language in HB 2886 contains compromise language resulting from close work with the Texas Medical Association and the Texas Hospital Association. The identical Senate companion was voted out of HHS unanimously and voted out of our chamber 31-0. Thank you, Madam Chair and committee members.
Thank you. Any questions of Senator Burton? All right, we have we'll open public testimony on House Bill 2886. We have a resource witness from Carla James from Texas Department of Licensing and Regulation. Could you come up, Ms. James? I have a quick question. And then Roland Leal testifying in support of the bill but not wishing to orally testify, Association of Texas Midwives. Ms. James, I just have one quick question. So this bill doesn't change, still the law that needs to be applied, right? Because I understand Dr. Buckingham's gone, but she was explaining to me that, you know, if that's in the eyes, it can actually eat away the infant's eyes. So it's still the law to do it. It's just that if a parent doesn't want it done, then and the nurse or the midwife doesn't do it, they can't be prosecuted. That's basically all we're doing. But it still will be the common practice to apply the ointment. Is that correct, unless someone specifically states otherwise?
Carla James, Deputy Executive Director, TDLR. That is accurate, Senator.
Okay. All right. So you don't think it'll change common practices in hospitals or anything like that?
I honestly can't speak to that, but this would allow someone who does not, the parent who does not want to have it done, the midwife or doctor will not be held accountable for that.
Okay. All right. Thank you very much. All right. Is there anyone else who wants to testify on, for, or against House Bill 2886? We'll close public testimony. Leave that bill pending as well. Do we have any other visiting? Oh, Senator Taylor. He's back there in the door. Larry, you're hiding back there, but it's your turn. You're not ready. Okay. Well, Senator Birdwell, I understand you need to go somewhere in a minute.
Appreciate your deference. I do have.
Of course. Let's recognize you on House Bill 3391.
Thank you, Madam Chair. Members, House Bill 3391 by Chairman Guerin relates to the creating of a specialty court for certain public safety employees. In 2009, the legislature passed law that created an optional pretrial diversion program for veterans who have committed a crime as a result of suffering from job-related post-traumatic stress disorder. The program, commonly referred to as the Veterans Court Program, has to be authorized by a county commissioner's court, and a defendant can only be admitted to the program with the consent of the attorney representing the state. HB 3391 creates this same optional program for public safety employees such as peace officers, firefighters, detention officers, county jailers, or EMS service employees who have been charged with a criminal offense due to job-related PTSD or other related mental issues. These individuals serve in a profession that is known for high levels of danger and stress. Placing them in a program that addresses the root of their mental health problems will provide these otherwise upstanding citizens with the opportunity to overcome their work-related challenge and allow them the chance to once again become productive members of society rather than simply putting them through the criminal justice system. Subject to your questions, Madam Chair.
Anyone have any questions of Senator Birdwell? Okay, we have one card. We have Chris Jones from CLEAT. He's in support of the bill. Hello, good morning, Chris.
Good morning, Madam Chairman. My name is Chris Jones with CLEAT, Combined Law Enforcement Associations, in support of the bill. And if you have any specific questions, I'd be happy to answer. It's a very limited bill to address some very limited circumstances.
Questions? All right, thank you for being
Thank
here.
you.
All right, anybody else want to testify on, for, or against House Bill 3391? Close public testimony.
Thank you, Madam Chair.
Senator Larry Taylor, are you ready? All right, you're recognized on House Bill 2015.
Thank you, Madam Chair and members. This is a bill that passed unanimously on local consent in the House, and it very simply amends the election codes to require a voter registrar to forward to the county chair of each county executive committee the information necessary to contact applicants that have expressed an interest in working as an election judge. Current law requires exclusion of the applicant's telephone number and address from disclosure, which obviously makes that difficult to contact them. So this just adds an exception that requires a voter registrar to forward that information to the county chair of each county executive committee so they can be contacted.
Questions of Senator Taylor? All right, we'll open public testimony on House Bill 2015, and we have Keith Ingram as a resource witness if anyone has specific legal questions. And then registering a position in support of the bill, Bill Fairbrother from TRCCA, Glenn Maxey from the Democratic Party, and Ed Johnson from the Harris County Clerk's Office. Is there
Madam
anyone
Chair?
else? Yes. Senator Birdwell.
I don't know if you have a resource witness.
Yes,
I
we
did
do.
have-
Mr. Ingram.
There are.
You sit here, and now we need you. See? All your time you sitting here. Thank you. Okay, Senator Birdwell.
Thank you, Madam Chair. My concern here is that the information on a voter registration card includes Social Security number and other items. Would this bill allow all those items to be provided, or just those specific to how the voter wished to be contacted?
That's right. It's only the contact information and that they're interested in being a poll worker.
So that none of the other information that comes on a voter registration card would be available to, is not transmitted.
That is correct. It would not be.
The respective county chairs.
That's right.
Okay. Thank you.
It would just be the list of persons who are interested in being a poll worker and how to contact them.
Thank you, sir. Thank you, Madam Chair.
Thank you. Anybody else want to testify on, for, or against House Bill 2015? Close public testimony and leave that bill pending.
Thank you, Madam Chair.
Birdwell only had one? Yep, okay. Senator Zaffarini, do you want to do yours? Okay, you're recognized on House Bill 59.
Thank you, Madam Chair. Madam Chair and members, due largely to media attention, winners of large lottery prizes too often become targets for burglary, theft, and requests for monetary assistance from distant and new friends and family members. House Bill 59 would protect lottery winners from crimes and unwanted attention. Generally, it would authorize a person who wins a lottery prize of $1 million or more to remain anonymous and prohibit all personally identifiable information from being released to the public.
Senator Zaffarini? Nope. Open public testimony in House Bill 59. All we have is a resource, Michael Angier from Texas Lottery Commission. Is there anyone else who wants to testify on, for, or against House Bill 59? Close public testimony. Leave that bill pending. Senator Lucio, would you like to be recognized on House Bill 3055?
Thank you, Madam Chair. Thank you, Madam Chair and members. Good morning. Current law prohibits election administrators from holding an elected office to ensure impartiality in elections. However, the lesser populated counties in Texas sometimes have difficulty finding someone to take on this vital role. House Bill 3055 would allow elections administrators in counties of less than 1,000 to hold or run for a nonpartisan office in a county outside their home jurisdiction. This measure would not compromise the impartiality of county elections administrators, as the offices they could hold are not affiliated with a political party, and they would not be in charge of running elections operations in their home county. Members, I have this situation, Kennedy County, which is right above Willacy County, right in the middle of the King Ranch, has a population of 434 citizens, and the administrator holds public office right now in Clayburgh County, which is the county north of it where he lives, but works in Kennedy County as the elections administrator. It's that simple. It's bracketed down to those counties in Texas less than 1,000.
Very small counties, yeah. All right, well, any questions of Senator Lucio? We'll open public testimony on House Bill 3055. We have Keith Ingram as a resource witness, and we do have someone against, so let's hear why they're against. Chris Davis from the Texas Association of Election Administrators.
Thank you, Madam Chair. Christopher Davis, Texas Association of Election Administrators, testifying against House Bill 3055. Our association feels that House Bill 3055 is antithetical to the principles of election administrators who must remain nonpartisan and apolitical. We're different by county clerks in that respect. We recognize the bracketing of this bill, and we sympathize with the needs of Kennedy County. I myself am from Cameron County, Senator Lucio's county, and we recognize this bill is meant for one county, because there's only one county in the state in that threshold that has an EA, that's Kennedy County, and we recognize this is for one individual, a city commissioner in Kingsville. But there are other remedies that Kennedy County could have gone through. There is a provision in the election code that allows for joint election administrators. In other words, a county such as Kennedy County could go into a partnership with adjacent counties that have sitting EAs such as Willacy, Brooks, or Hidalgo, and go into a joint election agreement where a sitting election administrator can administer elections from multiple counties or both counties, as well as a reversion of election duties could be done to either the county clerk in Kennedy County or a tax assessor collector. We just feel that this provision, this bill, goes against the very definition of election administrator and the apolitical qualities that we have.
And hey, of course, Senator Lucio, you're
That
right.
option might seem reasonable just in speaking about an option with a county next, but the infrastructure has it where you have to travel long distance, while Clayburgh is just a few miles down the road. So this is convenience, and this is something that would help. If I heard you right, you're telling this panel that there's other options that one can take without having this legislation. Did I hear you right?
Yes, sir. You did, Senator.
I respectfully disagree in that infrastructure has a lot to do with being able to serve people and get to where you need to go in a faster time. So we do have a unique situation here, Madam Chair, members. Thank you.
Any other questions of the witness? Thank you. Thank
you,
you,
ma'am.
sir, for being here for your input. Is there anyone else who wants to, well, we have some people registering in a position. Bill Fairbrother from TRCCA in support of the bill. Ed Johnson, Harris County Clerk's Office, supports the bill. Brad Parsons, representing himself, he's a campaign consultant, he's against the bill. Is there anyone else who wants to testify on, for, or against House Bill 3055? Close public testimony. Thank you very much. Okay, Senator Hughes, you have Senator Perry's bill, I understand? Yes. House Bill 3321.
Thank you, Madam Chair, and thank you and your team for working with us to hear this bill. And members, we lay out this bill on behalf of Senator Perry, and speaking of small counties, it affects 4 counties in his district in the western part of our state. In most county courts, there is the authority to hear cases on protective orders. Back in the late 1990s, when there were some recodifications and consolidations going on, these 4 counties, Baylor, King, Knox, and Cottle, had that jurisdiction removed. House Bill 3321 would give that back to them, and it's going to help. It would help folks living in those areas. We don't believe it's controversial. Passed the House 145 to nothing, and we offered to the committee.
Okay, any questions of Senator Hughes for behalf of Senator Perry? No? Anyone want to testify on, for, or against? What's the number? House Bill 3321. Close public testimony. Leave that bill pending. Senator Hughes, would you like to be recognized on your bills?
Yes, 658.
658.
Very much.
You're welcome. Very much.
Thank you, Madam Chair. And again, with all the bills this committee has asked to hear, we thank you for working with us on these. This bill comes to us from Representative Bernal over in the House. It allows priority for those unable to wait in long lines because of a disability or illness. It's really about a safe and dignified approach to help these folks vote. It also requires that signage be posted so that folks know this is available to them. I know that many of us hear from time to time about constituents who had a problem because of a disability or an illness or a mobility problem that kept them from voting because of the long lines. And so this would just say that for those folks in those situations, it makes it clear they're allowed to go to the front of the line and cast their vote. We don't think it's controversial, but we're going to have some good testimony, I'm sure, and we offer it to the committee.
Senator Hughes, I just have a brief question. Does this apply also to like an elderly person or someone, or?
I understand.
Sometimes I'm waiting in line and I see someone who's, looks like they're having a hard time waiting that long, so.
As I understand, that's the intent as well. Any folk, for whatever reason, if they're mobility or problems like
Okay.
that, it's supposed to give them
Right.
some help. And I think we understand most folks are going to do this anyway and allow them, but the folks affected by the disability or the mobility problem may not know to ask, and they may get lost in the shuffle. So this is to make sure they get prioritized. I'm sure folks who are able-bodied wouldn't mind waiting for them, and if they do mind, that's too bad. They ought to wait for them. So.
Yes, sir.
Thank
All
you.
right. We'll open public testimony on House Bill 658. We have Keith Ingram as a resource witness, and we have Ed Johnson and Chase. Are you here, Chase? Chase Bearden? Yeah, you can come on up. Or you can wait till he leaves, Chase. That's fine. Yes, sir. Okay.
Ed Johnson with the Harris County Clerk's Office, and we're against the bill. I think currently election judges have the authority if they want to help assist somebody that needs assistance in their polling location to do it. I don't know that you need a law. These
Just
people
interrupt
have
and say, show Senator Nelson present. Keep going. Yes, yes, there she is. All right.
an election judge has the same powers as a federal judge on election day, so if they want to help assist somebody cut in line or something like that, I believe they already have that authority to do so. And in Harris County, if they see somebody that needs assistance, we encourage them to help them, usually provide them a chair to sit in, something like that, so that they don't have to stand in line. I think it is a bad practice to ask handicapped people that could have life-threatening problems to come to a polling location. So they all qualify for a ballot by mail, and I would rather see them vote safely from home than to jeopardize, their health by trying to come out to a polling location. So, we think that there are better solutions to this.
Okay, I have a question. But does this harm anything? trying to understand your opposition, because I respect your position, but I just don't see the.
Yeah, I could see
good
it.
thing.
Yeah, I could see it be used to put the judges in jeopardy, because now you're asking for that judge, when people are making requests, to make a decision whether or not that they are handicapped or not. Putting pressure on that judge to make some kind of ADA decision, which could possibly, involve them in some kind of lawsuit, maybe. We would not want to put our judges in jeopardy with having to make those kind of decisions. Like I said, I think it's better for them if someone really is handicapped, that they apply for a ballot by mail. They can vote.
But some
that.
people want to go vote. I mean, they have a right to go vote, whether they're
Yes, they do. And
handicapped or not.
if they can physically do that, I think it's good. But I mean,
Exciting to go. People, they like to go vote. My mom is over 90 years old, and she generally votes by mail, but she tells me all the time that she misses going to the poll. It's exciting.
Like
she likes to shake everybody's hand. She talks to everybody.
I took my grandmother to the polls as long as she could still get up and go walk.
It would be hard for her to wait in line, and it would be nice to have, And this isn't for my mother. Don't everybody start writing. I didn't even know about the bill
currently
yesterday.
Currently, for that practice in Harris County, we tell the judges several things are done. Either there's a placeholder put in line where they are, and their chairs provided that the people can sit it until their point in the line comes up, to try to keep things fair. So these people are being assisted, and I think more particularly they're referring to people that their health is so poor that they can't wait that time in the chair. And if their health is that poor, they shouldn't be risking their health, risking their life to come
That's
to.
their decision.
Well, that is true.
Not
That's
ours.
the decision. But I would hate for someone to do that when there are other options that are safer for them to do.
It's just not our position to make that call for people, in my humble opinion. Sorry.
No problem.
Yeah. Does anyone else have any questions of Mr. Johnson? Okay. We have Chase. You can come on up, give your perspective. If y'all could assist there, thank you very much. It's not the roomiest room. Yes, you're recognized, sir. Take your time.
Hello, Chair. Chase Bearden, Coalition of Texans with Disabilities. First of all, thank you for having us. We are for this bill. It just puts in a law that elected officials do have a choice, and I think something that kind of gets missed is that it talks about a substantial disability. And for me, I do have a substantial disability, and if they ask me, depending on the day, I can't tolerate heat. So if I get there and there's a long line from my injury, I don't sweat anymore. Overheating quickly can happen. That's one of the issues I deal with on a day-to-day basis. I don't want to vote by mail. I've always participated. Everyone else has. I think you have that right. We could make elections a lot cheaper and not have to have them accessible at all if we went to vote by mail. And it's just my own opinion, but I think people need to participate. And this is one way that helps them. Not every time someone shows up to vote, a lot of people, and I know many legislators over the years, have broken their legs by the end of session and had to deal with something very painful.
Or our necks.
Exactly. There are a few vehicles that run into you. Sometimes you're in that period where you do need to be able to get some assistance because it may be pain. So just even waiting long periods. There's also other people that have attendants that are coming with them, that actually the personal attendant taking care of them. And as we all know, for those of you on Article 2, we don't always allow that much time for them to have that attendant with them. So being able to go out and be able to vote, get that done, and get back, these are the types of things that are put in place. I think the election officials can make a good and wise, easy decision. It's something that we can do, and it's the right thing. And I think people who need it will use it. There's also, I've heard that people say, well, we can just bring it out to your vehicle. I do have friends who use that option. For me, it's actually easier to use the machine when it's up in front of me. And just like everyone else, all my years of service and things I've done, I want to participate. And I think this will help others, especially as we get some that are aging that still need to go to do that. And yes, we can still use other options too.
Senator Lucio, you're recognized.
Thank you for your testimony. Certainly appreciate you being here and being a spokesman, especially for Texans with special needs. I'm sure that you gone to many public places. How have you found it, especially here at the Capitol, to be able to access yourself in and out of this building and other public buildings in where you visit? How is that?
Depending on the building, they all get difficult. There's plenty of Senate, not House offices that are virtually impossible to get through once you get in the front door. This building is a struggle. There's only one entrance, so when it's full, it's kind of an issue. Representative King, after she broke her foot a couple years ago, had asked us to look at a lot of that, and we put forward. But there's still a lot of buildings in this state that are difficult. The school that I voted at, they moved a portion of it, and the ramp that was going up to the doors was actually way too steep to get up there, and I had to find someone to push me up it. So there's still issues we run into here and there. But yeah, it depends on the day, finding parking and then still being able to get in. That can be an issue.
I hope because of the advances that we're seeing in modern technology, someday you won't even have to leave your home to vote. Be able to do it with a fingerprint, take a picture, the computer can go to a database where, your records are and you can vote. I'm hoping we're heading in that direction, not only for people with special needs, but for everyone in this great state. Thank you very much for your testimony.
Thank you, Senator Lucio. Any other questions? Okay, thanks for being here, Chase. We have several folks registering a position. Glenn Maxey from the Texas Democratic Party in support. Chris Davis, Texas Association of Election Administrators in support. Jeff Miller, Disability Rights of Texas in support. Is there anyone else who wants to testify on, for, or against House Bill 658? We'll close public testimony. Members, I have to go to a bill signing at the governor's office, so Senator Hughes is going to take over, and I'll be back as soon as I can. Thank you. Okay.
Is she expecting that? This time, the chair lays out House Bill 2703 by Representative Munoz, sponsored by Senator Uresti, and recognizes Senator Zaffarini to lay out the bill on behalf of Senator Uresti, 2703.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 2703 is by Representative Munoz, sponsored in the Senate by Senator Uresti. In protracted divorces, courts sometimes appoint receivers to oversee the finances of divorcing parties with the purpose of preserving the assets at stake during the divorce. The current process for the appointment of a receiver does not require the court to justify the appointment. House Bill 2703 creates transparency in receivership appointments by requiring the court to provide the findings of fact and conclusions of law justifying the appointment of the receiver within 7 days of the receiver's appointment. The court also must provide justification if it requires a bond in connection with the receiver's appointment, something typically required to cover the cost of the receivership. There is a committee substitute, Mr. Chairman.
Chair lays out the committee substitute. Senator.
Thank you. The committee substitute simply extends the time that the court has to justify the appointment of the receiver from 7 days to 30 days to give the court sufficient time. Currently, courts have wide latitude to appoint a receiver in divorces. The committee substitute for House Bill 2703 would add much needed transparency to this process and would encourage courts to appoint qualified and neutral individuals and to make receivership appointments only when necessary and appropriate.
Is there any questions for Senator Zaffarini? So no one has indicated their desire to testify. Is there anyone here, we'll ask, wishing to testify on, for, or against committee substitute to House Bill 2703? Seeing none, public testimony is closed, and the bill will be left pending at this time. This time the chair lays out HCR 59 by
Thank you.
Representative Gann, and Representative recognizes Senator Lucio.
Thank you, Mr. Chairman. Members, House Concurrent Resolution 59 by Representative Bales was filed in order to urge Congress to pass a budget. Here in Texas, we are charged with adopting a fiscally responsible budget each legislative session. It should be no different at the federal level. Considering the different roles of government, adopting a public budget is one of the most integral and fundamental duties of responsible governing. For far too long, Congress has proven itself fiscally irresponsible, leading to a crushing national debt. Members, HCR 59 is a bipartisan resolution that expresses the importance of adopting a federal budget. This resolution received 136 aye votes in the House and Texas House, and I ask for your favorable consideration so that we can send a message to Washington.
Senator Lucio, members, any questions on HCR 59? And no one has indicated their desire to offer public testimony. I'll ask, as we open that up, is anyone here wishing to testify on, for, or against House Concurrent Resolution 59? Hearing none, public testimony is closed, and the resolution is left pending at this time. 3356, okay. This time the chair lays out House Bill 3356 by King of Uvalde and recognizes Senator Lucio.
Thank you, Mr. Chairman. Pleased to lay this out for Senator Creighton. Currently, an individual who is receiving an annuity through a structured settlement agreement may sell a portion of that annuity for a lump sum. These structured settlement agreements must be approved by a court order. Detailed personal and financial information about the individual and the individual's dependents is required in the application for approval of the agreements. Information such as names, addresses, age, phone numbers, dependents' names, and their information may all be disclosed to the public in these applications. House Bill 3356 by Representative Tracy King would protect individual information by requiring a court, upon request of the annuitant, to, number one, redact personal information on all documents it receives in connection with a petition seeking approval of a structured settlement, and two, make two mirroring versions of any order the court issues in a structured settlement transfer. Of these two versions, the first would exclude all personally identifying information that is made public immediately, and B, the second version would include the personal information and would be sealed for 6 months. After that time, the court or any member of the public may unseal the order. The bill will protect personal information while also allowing an unredacted copy to be available in order for different institutions that purchase annuity payments to access the names of the annuitant on the order. Thank you, members, for your consideration.
Thank you.
Bill.
Thank you, Senator Lucio. Members, any questions for Senator Lucio? We'll open public testimony, and the chair calls Ron Body, testifying for the bill. There's Ron Body, Esquire. Welcome. Please introduce yourself and offer your testimony.
Thank you, Mr. Chairman. Members of the committee, my name is Rod Body. I'm the General Counsel of Seneca One Finance. I am testifying in support of the bill, and I'm happy to answer any questions.
Members, any questions for Mr. Body? Thanks for being here.
Thank you.
Anyone else wishing to testify on, for, or against House Bill 3356? Seeing none, public testimony is closed, and the bill is left pending at this time.
Chair lays out House Bill 1378 and recognizes Senator Hughes to explain the bill.
Thank you, Madam Chair. House Bill 1378 we offer on behalf of Senator Davis of Harris County, Representative Sarah Davis, of Harris County, and who brought the bill over there. Currently, before authorizing political contributions or expenditures greater than $500. A general purpose committee has to appoint a campaign treasurer 60 days before the contribution or expenditure, and has to have accepted contributions from at least 10 people. Basically, this is a waiting period for general purpose PACs. In August of 2014, the Fifth Circuit Court of Appeals ruled that this waiting period violates free speech. And so this is in statute, but it's no longer effective because it's been struck down by the federal court. So House Bill 1378 eliminates this waiting period and aligns the law with the law. And it prevents future litigation against the state, because right now, to comply with the federal court, we'd be in violation of state statutes. This is a cleanup. Oh, it's a good sign. It's a good sign. That's all the bill does, as we understand it. Thanks, Senator.
Are there questions of the author?
That's right.
Not, the floor is now open for public testimony. Is there anyone who would like to testify for, against, or on House Bill 1378? Not, public testimony is closed and the bill will be left pending. Chair lays out House Bill 2121 and recognizes Senator Hughes to explain the bill by Representative Cyrier.
Thank you, Madam Chair. Members, this bill from Representative Cyrier over in the House, and also Representative Anderson of Waco, has to do with contracting with the government. As we know, this, because of sovereign immunity, you can enter into a contract with the government, with the state, and then if the state breaches the contract, you have no recourse. As a result, folks are less likely to contract with the state, or if they do, they require a much higher cost to do it, raising the cost to taxpayers, interfering with commerce and private business. And so over the years, the legislature has worked to mollify this and to maintain balance while making it easier for the state to do business and to treat people fairly. Chapter 2260 of the Government Code gives a means for an agency to have a dispute resolution mechanism when there is an alleged breach of contract. They've got to negotiate, and if they can't reach an agreement, there's a contested hearing at the State Office of Administrative Hearings. In current law, these suits are for architectural engineering and non-textile construction services. This bill provides that in those cases, and if certain conditions are met, there can be an award of attorney's fees if a party breaches the contract for professional services. There's a limit on it. This is not anything that's going to run away, but it's important that people can contract with the state and be treated fairly, and again, that the state isn't held up in the contracting process if we don't have these protections in place. That's what the bill does, and it came to us from the House. We believe it's a good bill, and we offer it for your consideration.
Are there questions of the author? The floor is now open for public testimony. We have one person registered in support of the bill, does not wish to testify. Michael, I believe it's Chatron. Is that correct? Thank you. Is there anyone else who would like to testify for, against, or on House Bill 2121? If not, public testimony is closed. The bill will be left pending. Chair lays out House Bill 2837 and recognizes Senator Hughes to explain the bill by Representative Dean.
Thank you, Madam Chair. This bill comes to us from Representative Jay Dean, who I represent in the Senate from over in Longview, a new member of the House who's doing excellent work. And under current law, the Secretary of State furnishes to voter registrars a list of that identifies the deceased registered voters from each county. And then a registrar cancels the deceased voter's registration when they learn about the person having passed away. Now, as part of their oversight, the Secretary of State can withhold funds if a registrar is not in compliance when performing these functions. And so what this bill is about is making sure that when we know someone has passed away and therefore not eligible to vote, that they are removed from the voter rolls. There's old jokes about dead people voting, but we understand there's potential for fraud, and not just that. These rolls need to be accurate and efficient, and so when someone has passed away, they need to be removed from the voter rolls, and that's all this bill's about. We think it makes sense, and it came through the House with no problem.
Thank you. Are there questions of the author? If not, the floor is now open for public testimony for House Bill 2837. We have a resource witness, Keith Ingram, from the Secretary of State's office. Are there questions for him? There are several people who would like to register their position on the bill. By unanimous consent, their name, contact information, and position will be registered in the record. Is there anyone else who would like to testify for, against, or on House Bill 2837? If not, public testimony is closed and the bill will be left pending.
Oh, there's just two bills is what I was trying to tell you left.
Oh, I thought
That's all.
you said
No,
no.
No, not at all.
Yeah.
Not at all. I'm just saying there's two more bills than that.
I got you.
Fairly out House Bill 3649 by Senator Hinojosa. Chair recognizes Senator Lucio to explain the bill.
The only thing wrong with these bills is they're kind of late.
Thank you, Madam Chair. Members, family violence continues to be a serious problem in our state. In 2015, there were 194,872 incidents of family violence, and 158 women were killed by their male intimate partner. 39 states have some form of enhanced state-level victim information privacy protections for victims of domestic violence. However, in Texas, Texas lacks strong legal protections for private conversations between domestic violence victims and their families' violence advocates. Currently, batterers or others who seek this information can obtain these private conversations with a court subpoena. As a result, advocates document little information in victim files, significantly reducing their usefulness. Disclosure of the intimate details of abuse in court re-traumatizes victims of domestic violence and jeopardizes victim safety. Victims of family violence need safe spaces to share details of the abuse. Enhanced privacy and confidentiality stand as critical elements of fostering a therapeutic and effective environment for victims to seek help. House Bill 3649 would ensure survivors of family violence are protected by making communications between survivors and family violence center advocates confidential and privileged information. That's it.
Thank you, Senator. Members, any questions for Senator Lucio? At this time, we'll open public testimony, and the chair calls Glonna Terry, Texas Council on Family Violence, for the bill, and we can bring a group of folks together, have a seat. We'll also call Vincent Giardino, Tarrant County Criminal District Attorney's Office, and Ashley, I'm sorry, hold on one second. A couple more. Ashley Tarasco, please come on up. I bet I got your name wrong. And from the Safe Alliance. And we got room for, is Chris still back there? Chris Jones, is he still here?
Registering position.
Okay, thank you very much. All right, thank you. Now, thank you. Please proceed. Welcome. Introduce yourself and proceed with your testimony. Thank you.
Good morning. Thank you, Vice Chair Hughes. My name is Gloria Terry. I'm the CEO of the Texas Council on Family Violence. Senator Lucio, thank you for laying out the bill. A little bit about the Texas Council on Family Violence. We're the only statewide organization that raises and elevates the voice of over 100 domestic violence providers across the state of Texas, much like Casa de Misericordia in Laredo, Friendship of Women in Brownsville, and certainly the Women's Crisis Center of East Texas in Longview. A little bit about the landscape you heard earlier. 197,000 calls to law enforcement was made because home was not safe. 72,000, primarily women and children, were served in programs across the state. And again, 158 women were killed. They ranged in age from 16 to 93. The recognition of these statistics tells us that the issue of domestic violence happens across the lifespan. We're here to register support for HB 3649, sponsored by Representative Herrero. It's important to note that it went out of committee at a vote of 138 for and 0 opposition. We want to thank Senator Huffman's staff, Sean and Roe. There were hundreds of calls made yesterday, and thank you for hearing those pleas to make sure that we were able to get a hearing today. The main things that I would share with you is that this bill will give the ability to straighten the safety net for survivors who are fleeing domestic violence and who seek support and help and safety from community-based organizations. And this allows Texas to, again, join the vast majority of other states who already have this enhanced confidentiality between an advocate and a victim. This allows advocates to be able to provide the therapeutic care, to hear people's crisis in one of their most vulnerable times. The Texas Council on Family Violence goes through an extensive process to vet these legislative agenda items. We convene a multidisciplinary committee. This has vast support from prosecutors, judges, other community leaders, and by far and above, we're hearing from our constituents that this is one of their top priorities. It will ease the administrative burden that they're faced with the number of subpoenas that they're requested for client files. And in addition, the most valuable aspect of this is that it allows a victim during his or her most vulnerable time to be able to share information without fear that it will be used against them at a later time. So as I close, I offer you these comments. If there is one success that you will reflect on this legislative session as we move past, there is no other effort that you can make that is without a fiscal note that it will exponentially increase the quality of life for people that are experiencing violence in their homes. Thank you for your time.
Thank you, Ms. Terry. Members, any questions for Ms. Terry? Thank you for your work. Mr. Giardino, welcome and introduce yourself and begin your testimony. Thanks.
Thank you. My name is Vincent Giardino. I'm a prosecutor with the Tarrant County Criminal District Attorney's Office, and we oppose HB 3649. The bill provides a privilege, and a privilege is something that allows someone to refuse to testify under oath. Currently, this only applies to situations such as doctors or clergy. It does not apply in situations of spousal privilege when there's violence. So there is a spousal privilege, but in acts of violence, the offender cannot keep the abuser from taking the stand against him. This bill would allow an advocate to take written notes of their conversation with the family violence victims. The intentions are very pure, but the idea is short-sighted given the realities of a domestic violence case. These cases are very near and dear to my heart. We, in Tarrant County, just started a dedicated family violence unit. That's why the bill troubles us so much. Details of an assault sometimes change in the days after the incident. Small changes are human nature. It's to be expected, and there are 100 reasons that might happen. But whenever I do hear these changes, the Michael Morton Act that you guys passed a few years ago requires me to disclose these to the defense. Now, I have had incidents where victims come to me and admit that they lied to the police. I've had them come up to me and change the facts to reduce the charge. I've had them come to me and start finally giving more of the savage details about what has been happening to them. It runs the gamut. Currently, advocates are told not to write any of this information down and not to tell prosecutors. I've reviewed the federal law, and it doesn't protect all information. That's frustrating enough for us, but this bill doubles down on that and would make them create a written account of the story and then not be able to testify in court. So there are two different ways that the defense would actually then be able to use the advocates as a pawn in their defense. Time doesn't permit me, absent questions, to go into those situations, but I do want to say there's a couple of ways this can be weaponized, but there are ways to fix this bill. First, an amendment that the privilege cannot apply to acts of violence, just like the spousal privilege. This would still protect other sensitive information that the victims and the advocates share, but when it comes to descriptions of violence, the truth simply must come out. Someone's future danger is at stake, and someone else's liberty and freedom is at stake. We have to know the truth. I've had more than 20 family violence murders last year, and while we've all been down here in Austin, we've had 8 more in Tarrant County. This bill potentially means that I don't get those files until those women are killed. The other way that this could be fixed is an amendment that if the defendant requests the file, any part of the file, whatever you guys allowed, closed, hidden, whatever, that the state also gets a copy. This will help prevent the defendant from using this during the trial in, having the victim. These defendants hold a lot of sway over the victim. That is a reality that we see every day. They will use this to keep anything that they tell the victim, or anything that the victim tells the advocate, under wraps. These defendants, frequently drive the victim to my office or to the Family Violence Center under the instructions of, Go in there, tell them it didn't happen.
Senator Zaffrini.
Sir, your testimony is very compelling, and I'm very interested in this bill, and I really do like it. And I noticed that you said that there were ways to fix the bill. This is a House bill. Did you make those suggestions in the House at that hearing for this bill?
I made the suggestions to the Texas Council on Family Violence before the vote. I made these two suggestions, and they decided not to go with them. So we started communicating on the Senate side. It's my first session. I missed the bill. We knew about it. We weren't able to get to it in time. After the hearing, but before the House vote, I did approach the Texas Council on Family Violence and spoke to them about these things, and we've had a somewhat continued conversation on it since.
Have you discussed your suggestions with Representative Herrero, the author of the bill, or Senator Hinojosa, the sponsor of the bill?
I discussed it with Senator Hinojosa, because by the time that we ramped up on this and started learning more about it, and I'd had the conversations with the Council on Family Violence, it was already out of the House.
Reaction?
I just left my card with staff. I never received a call back. I believe they felt that I was working more with the Texas Council on Family Violence. So we do have two ways to fix the bill. We agree with Texas Council on Family Violence on most of the issues. In fact, one of the issues that was either recently signed by the governor or is about to be signed, we did support in committee. But we have some concerns based on we're in the trenches. And if you don't think that this stuff can be weaponized, please come watch some of your family violence cases in your county. With that, I'll have any other questions.
Thank you for your testimony, and you certainly do have our attention because we know that you don't like family violence and you prosecute these cases, and we know how much you guys work together. And Senator Zaffrini raised an important point that in the process, it's really helpful to get involved with these as quick as we can. We understand there's a lot going on. Everyone probably understands but me, but help me. I don't do criminal practice, so walk me through again what this would look like in trial. Play out the concerns you're describing. Can you help us with that?
I appreciate that. Thank you. Again, they're under such sway from the abuser. The abuser takes the victim to safe haven and tells them, go tell them it didn't happen, or tell them it's your fault, or change the facts in some way. Make it, instead of a choking case, make it an assault case. So that's what they do. They go in there and they do what they were told. Now, that's the victim's privilege under this bill. So that's going to sit written down, documented, where they told the family violence advocate what didn't happen, but they're going to tell them, what the story is that day. Victims often ignore me after that. I don't get a whole lot of cooperation sometimes. So at trial,
so the victim has gone to an advocate and made this statement, but you're not aware of it.
I can't be aware of it.
There's no way you can know. Okay.
The advocate knows about it, and the victim knows about it, and they've told the defendant and the defense attorney. Everybody knows about it but me.
Okay.
That stays under wraps until the day of trial, where I have had to, and I've had to do it, impeach victims. I had one.
Now explain to the non-lawyers what you mean by impeach. It has nothing to do with the. Go ahead, please.
No. A victim will change their story. Sometimes they'll be fine until the day of trial, then they'll change. And if that doesn't match what the evidence is, I had one where a defendant ripped part of her ear off with his teeth during the fight, blood everywhere. But the victim, who had been serially abused by this one man, came to me and said, it didn't hurt. Well, it didn't hurt is kind of a term of art in family violence, because that is the definition of bodily injury. So she's telling me it didn't hurt. You can't tell me this didn't hurt. So I have to impeach that victim on the stand. I have to go through the facts, then when she gets to that part, she'll say it didn't hurt. So I've got to show that picture to the jury and say, jury, do you believe her on this thing? And I've got to impeach her. Now, that's kind of a dramatic episode, but that's an example of impeachment, where I get to put that credibility to the jury and say, look at the photos, match it with the rest of the story, what do you think happened? In most cases, I've got a hair pull or a bruise or something like that. So when this victim has the story written down on paper in the advocate's file, the defendant can spring that on me at the last second. So I've already impeached the victim, and now the defendant can bring forth that file and say, look, she's actually been more consistent. She testified today, and this is what she told the advocate just a week or so after the offense. I wouldn't know it until it was too late. What that does is confuses the jury, kicks up a bunch of dust, and potentially causes a not guilty. Another way that this could happen, the Victim is telling more episodes of family violence. She's disclosing more than was originally reported to the police officer. And this information is written down, but then it's kept in that file where it is kept secret from me. The defendant's threats can still keep the victim's information under wraps. I will never know about it. Now, this is an ethical quandary for a doctor to which privilege applies. The legislature says privilege applies there, and okay. So that privilege applies to a doctor, and that's a hard enough ethical decision for someone who's been practicing 20 years and has years of education and training. These family violence advocates are qualified to do this after 20 hours of training, and that's a lot to put on them when, if they could get me the information, we could save a life.
Okay, and current law, in the absence of this bill, in the situations you just described, what would happen if this were not in place?
And we're still, as this has come up over the session, we've started talking with the Texas Council on Family Violence because we think we also have a disagreement on the way the federal law reads. Currently, the advocates are trained not to disclose this information. We think that the federal law just says that location information and certain information is not disclosed. The practices, I think, at different offices vary. Sometimes there's a lot of information sharing, sometimes there's not. I'm not looking for every deep secret that the victim shares with the advocate. I'm interested in making sure that I have charged the right person with the right crime. And I have to shine a light on all of this. And that's what we do in the trenches, and that's, and I know that they're in the trenches too. They see some horrible stuff, but we get our share of it. And we just want to make sure that everything is disclosed. If there's a different story, we need to know about it. Not all different stories are bad. Sometimes it's more details. Sometimes it's details of other abuse. Sometimes, though, it's things that make me need to change the charge to get the right charge on the right person.
Current law, are you able to go to either call the advocate as a witness or subpoena documents from them? How do you find out about this currently?
Currently, we can find out about it through the advocate.
And again, knowing what your goal is and what the Council on Family Violence goal is, what everyone's goal is on child abuse, but to make sure I'm clear, if this privilege were put in place, would this privilege would it hinder prosecution of these cases?
I believe it would hinder prosecution of these cases, yes. You've given us a lot of great tools over the years. The ability to use other instances of family violence in the actual case that we're prosecuting, if that is what, tempers the victim's view towards the assault, if that's what causes them to be reticent to testify. You've given us some fantastic tools over the years. And this would hide some of those incidents, and it would, it would inhibit our ability to effectively prosecute these cases.
Thank you. I thank the members for my indulgences. I try to understand this. Madam Chair, that's all I have for the witness. Pass the witness.
Yeah, and I'm sorry I walked in late, so I'm getting the tail end of this, but I think I get the gist of it. But I have a question for you. So I know we all remember the Michael Morton Act and the obligation, of course, that the state rightfully has to produce all evidence, basically, especially any exculpatory evidence. And the state is charged with, if anyone's an arm of the state, knowing it, rather, even if you maybe didn't even know it. So do you think that this could kind of step on the toes of that in any ways? Because sometimes there could be literally exculpatory information included in that. It could be,
That was an initial concern, yes.
Yes.
We have a close relationship. We even share offices with our One Safe Place and our safe havens, and we work very closely with them. I do not trust that no court will ever say this is not become, at some point, an arm of the state. Now, in talking with the Texas Council on Family Violence, they said that our memorandums of agreement could be modified and that there might be a way around this. I think my office is going to seek an Attorney General's opinion, especially if the bill is passed, on whether or not this would be. As you know, after Michael Morton Act, if a police officer has something extra in his file that he's never disclosed, it's not the defendant's fault, it's not the judge's fault, it's not the jury's fault. Who's left? We have broad shoulders, it's the state's fault.
Right.
But occasionally, and some of the newer court opinions have actually held this against the prosecutor and has potentially affected their bar card. So we're very, very sensitive to all information getting out. We hemorrhage information. We want everything out. Let's just do this right the first time and not ever have to come back. So yes, that is still a concern. It's less of a concern after speaking with them, and it'll be less of a concern when we just know how the Attorney General feels.
Okay. All right. Anyone else have questions of this group? Okay, let's see. So where are we? I'm sorry.
This lady,
She's next.
not testifying. I'm sorry. We got
Sorry, I came in midstream here.
Jardino has, Terry has. There's one with a card. I'm sorry.
That card.
The lady on the list.
Missing a card. Ashley?
That's her.
Ashley Jaraska. Sorry, we found it. You're recognized.
Yes, thank you so much to Chair Huffman and Vice Chair Hughes for the time to speak today and for adding this critical bill to the hearing today. We really appreciate that. My name is Ashley Jaraska. I'm the Information Systems Director and Custodian of Records for the SAFE Alliance. I'm here today in support of HB 3649, sponsored by Senator Hinojosa and authored by Representative Herrero. SAFE is a merger of Safe Place and Austin Children's Shelter. Our goal is ambitious and simple: stop abuse for everyone. We work with over 3,600 adult and child survivors of family violence every year. I have worked with many, many subpoenas in my time at SAFE. Confidentiality is critical to help seeking and healing. A key reason why domestic violence is so shattering is the dissolution of trust within close relationships. When anyone chooses to seek help from SAFE, we begin by building that trust again. Foundational to trust is the idea of confidentiality. It also serves to bring hope to a survivor that trust and healing can be had. With one subpoena that I remember vividly, I spoke with a person who had been receiving services from us for many years and had made significant progress in her healing. She had experienced a long history of abuse and in the hopes of healing had shared her experience candidly with her therapist. The client wondered aloud to me if she shouldn't have shared so much despite those open conversations being foundational to her healing. This is a huge resource issue for us in terms of training on confidentiality and records keeping. We do ongoing training on records keeping and how to limit notes because of how it can get used against victims in the court of law. In another case that I worked on, we reached out to a client whose records had been subpoenaed to determine what concerns she had with us releasing the records. She worked hard to take steps to ensure that her former abuser couldn't contact her, and she called us back extremely upset and concerned that the information might get out again. As an agency, we have to be able to reach our clients, but we also fear what could happen if that contact information gets into the wrong hands. For me, the thing that keeps me up at night is the idea that a person could receive help and healing from SAFE, only to have their life upended yet again with that information being revealed in a way that jeopardizes not only their safety, but their ability to seek help. HB 3649 would help prevent that from happening by directly supporting victims when they need it most. Thank you so much for allowing me to speak in strong support of the bill today, and I'm open for any questions.
Yes, Senator Zafran, recognized.
If I may ask a question of the two women who have testified now.
Yes, of course, whoever you
How
like.
do you respond to the testimony from the other witness?
I respectfully disagree with a lot of the points that Vincent has made. I think that there's inaccuracies in the things that he has presented. Bottom line for me, if you are using a client file to make your case, your criminal case, that's the weakest part of it. If you did not collect evidence, if you did not do your due diligence, it cannot be hindered solely on that case. When we talk about victim safety, we're talking about client files in real time. Prosecution, it goes to court a year, maybe 18 months later. So by that time, if the advocate has not developed a level of rapport with that victim, nothing's going to happen in 12 months or 18 months. So certainly there's a lot of work that we need to do together. In terms of the prosecution field opposing our bill, we have had extensive conversations with the Texas District and County Attorneys Association. Jaime Esparza, DA from the 34th Judicial District, testified on behalf of this bill on the House side, and District Attorney Jennifer Tharp was scheduled to speak on this bill in this hearing.
Was there any similar opposition testimony in the House at the hearing there?
Opposition, no. There was no opposition offered.
How do you balance the safety and the healing for the victim with the need to prosecute the perpetrator?
How do we balance the safety and the need? the current practice is, because we are getting subpoenas in significant numbers. You just heard that the custodian of records here for Safe Place. And the recognition that, and many times that information can be hurtful to the victim, not to the perpetrator. It's the things that she's disclosing that are reflecting negatively on her ability to parent, on her ability to convey what is at the root of the services that she needs. Our practice has been, you do minimal notes. You do absolutely the minimum, because in too many cases, that services that was needed, that information that she shared, was detrimental to her, not to the person that committed the violence.
In my experience, because of the limited notes that advocates keep, typically prosecutors find that when we do turn it over, my understanding from them is that it's not particularly helpful to the case. But what we are finding is that the abuser then hears or gains access to that information, and then in other ways uses that against the victim. So it ends up not having much weight on the trial in the experience of the cases that I've worked on. But it does cause high levels of safety issues with that client, with that victim, after the trial's over, if, for example, the prosecution is not successful. And even if it is, because they can have retribution from family members or friends of the abuser. So just wanted to add that. And the way that we balance those things is we absolutely work with survivors to encourage them to work with prosecution for these crimes. And we're not able to build that rapport with survivors if they feel like the things that we're writing about them and building that rapport are going to be used against them by their abuser. So we feel like we can more effectively support the state's work if we can work with survivors to coordinate with the state in that prosecution.
All right, thank you very much for being here. And we have several folks registering a position. Oh, we have two more to testify. Sorry about that. Okay, Jennifer Tharp. Jennifer, you can come on up. And Aaron Setliff. Okay, very recognized.
Thank you so much. If I sound out of breath, I am. I literally ran from the parking garage.
That's fine.
Okay, so a few things to take note. I did have a chance to hear Vincent's testimony, and I think he makes some good points. And I have to say, since Michael Morton has passed, as a prosecutor, you often find yourself in this difficult position. You don't want to in any way be accused of withholding any type of information. As a prosecutor, probably one of the most difficult aspects is when it's information potentially that's out there that you don't actually know about or have. So when this idea was floated at the Public Policy Committee for TCFE, which I co-chaired this last session, I have to say I wasn't a big fan of it at first until I heard one by one advocates explain their reality. The reality of, yes, we're trying to give counseling help, but we can't take notes because we're worried that it's frankly going to be used against her. Not by prosecution, but by him. And imagine the situation where you finally get up the nerves to leave that violent situation and you just want to go somewhere for help. That's all you want. You want help. Because think about it. The idea of doing this therapy is for her to hopefully move forward. And if the message is sent by him that there's nowhere you can go, that you will ever be safe, in the sense that you can never tell anyone about it, because I'll follow you with a subpoena. And that's what I found out, the reality that these shelters are dealing with, is the information, the seeking of the information. It's not that he really wants to know what is being said. He wants her to know that I will always have control over you. So frankly, as a prosecutor, I like this bill because it's not a question of me hiding information. If this doesn't go forward, I guess I would beg the question of, now as a prosecutor, are we required to subpoena all these files for the potential of some information to be in there? I don't want to be in that situation. Yes, prosecution can help. Yes, sometimes batterers need to be held accountable. But frankly, I can prosecute someone all day long, but until she gets that therapeutic help, she's probably going to find herself back with him or back in another abusive situation. So the therapy is just as important as the prosecution, and I think this legislation is a good balance of just that.
Sure, Senator Zaffirini?
If this bill passes, if it were to pass, would the victim have a choice of making the information confidential or disclosing it?
A victim could always disclose to prosecution that information.
So it wouldn't have to be confidential.
No, a victim holds those keys in her hand.
If she felt it was to her advantage, she could release that information.
Absolutely.
That would help the prosecution.
Absolutely.
May I follow up briefly on Senator's question?
Hughes, of course.
Well, thanks for your testimony and for your perspective as a prosecutor. It's helpful, certainly to me. And Senator Zaffirini asked if the witness could decide whether it would be released or confidential, and I think you said the witness could release it. But the other part of her question might be, could the witness say, I don't want this released? Does the witness have the key that only works one way?
The witness could choose to exercise that privilege, absolutely. And I'll be frank with you. There's a lot of times where I can want to go forward to protect a victim, and that victim refused to testify. Now, in a lot of cases as a prosecutor, sometimes the better maneuver is to not go forward on that particular case. Any prosecutor who tells you that we go forward on every single case is not being 100% accurate with y'all. There are certain times where we only have so much evidence to utilize. So I guess my question is, if the victim's information and sharing in this therapeutic session is just that, because you look at what information is covered, it's information part of therapy. So from a prosecutor's perspective, what details are we going to get that's really going to make or break a particular case? Unless we're trying to put a victim on the stand to then turn around and impeach them, which you cannot do. You can't call a witness just to turn around and impeach them.
Thank you. Thank you, Madam Chair.
I would just add, I mean, I get that a lot of times, my experience, the victims just don't want to proceed, and you have to do what you can, and sometimes we did our very best to compel them or try to gather other evidence. But and Senator Hughes tells me that Vincent, you had a couple ideas for an amendment. Is there a resolution here? I see both sides of this.
Absolutely.
To be honest, I don't think it'll get out of here the way it is. So, but I don't want to leave this problem, unsolved if there's a way to solve it. So can the two of you get together?
Absolutely.
Try to come up with something that everyone can live with, because it would be nice to try to address this. We have mixed votes up here, so it's not going anywhere unless you fix it. So that would be my advice, because I'd rather solve problems than just, cut things off. So just making that announcement. You don't have a lot of time, just telling you that much. Everybody knows that, so if y'all want to get together and talk. And, sir, you're recognized. Yeah.
Thank you, Chair. I'm Aaron Setliff. I'm the Director of Policy at the Texas Council on Family Violence. So I work for Gloria, but I come to this having been the chief of the Domestic Violence Unit out in El Paso for several years before coming to this work. I just wanted to briefly address a couple of the points. First off, starting with the suggested fixes. The suggestions were that we take any criminal violent acts out of the privilege. The very nature of therapeutic services, she's telling a story of violence. That would be a very difficult thing to change. The other suggestion that that Vincent has offered, the Tarrant County DA's office has offered, is if the defense has it, that they must then turn it over to the state. We are very open to that idea. I don't mind the state getting discovery in that fashion, and we'd be very open to changing the bill to reflect that if the information is turned over to one side, the other side would have it. I think that could be done. I could write it in the next 5 minutes. I do want to just point out that currently the practice is not to take notes. So none of these case files, if they're being subpoenaed right now, are useful in the manner that we've been discussing. This would be a change where we would encourage people to add notes. So we're talking about the potentiality for the possibility of usage, not the actual current practice where prosecutors are using notes for this purpose. And in terms of the Texas Council's approach to supporting prosecution, strangulation and suffocation, continuous violence against the family, continuous violation of protective order, the ability to hear more information about the relationship of the parties, all of those were our legislative agenda items. So we very much understand and support and want prosecution to happen. We're just asking that we make a policy decision together as a state that we want victims, those 72,000 people that were served in shelters, to be able to get the therapy they need for what they've shown up for. Thank you so much, Chair.
Okay, thank you. Any questions? All right, do we have anyone else who wants to testify? Just cards, registering positions. Chris Jones, 4, from Cleat. Chris Kaiser, Texas Association Against Sexual Assault, in support. Houston Area Women's Center, in support of the bill. Is there anyone else who wants to testify on, for, or against House Bill 3649? We'll close public testimony. I would just ask the stakeholders, interested parties, see if you can get with Senator Hinojosa, come up with a solution. You'd have to do it today, and we'll see what you can come up with. This is pretty much our last hearing, so we'd have to be creative, but I can be creative if I need to be. But okay, but y'all need to be in complete agreement. That's the deal. Okay, thank you. Okay, members, that concludes all the bills that we're going to hear. We're going to stand at ease until 10:30, where we were going to have a vote, and I think the other members know that. So we'll come back at 10:30 to vote. Thank you.
Madam Chair, we got a quorum.
Yeah, I think you and I can figure this out.
I wanted to show you the uniqueness of this.
Oh, I'm fine with your bill.
Yeah, I appreciate it. I didn't want to be argumentative.
No, I don't
It's
care.
too far. It's too far away to.
Yeah.
And then you never know. I mean, what if you don't get one? And there's one available there.
Yeah, but it's cool.
Yeah, I appreciate it. Thank you.
Hi. because
They may say something FYI, but I think you have to.
it's unpredictable. So,
Yeah.
okay, Senate Committee on State Affairs will come to order. We will move through these rather quickly, so if you need me to stop, just say so. Chair brings back up House Bill 2471, sponsored by Buckingham. Senator Hughes moves 2471 be recommended favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes,
No, 2471.
Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 2471 will be reported favorably to the full Senate. Senator Hughes moves to be certified for local non-contested calendar without objection, so ordered. Chair brings back up House Bill 59, sponsored by Senator Zaffarini. Senator Hughes moves House Bill 59 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 59 will be reported favorably to the full Senate. Senator Hughes moves to be certified for local non-contested calendar without objection, so ordered. Chair brings back up the committee substitute to House Bill 214, sponsored by Senator Burton. Senator Hughes moves we adopt the committee substitute without objection, so ordered. Senator Hughes moves the committee substitute House Bill 214 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman. 6 ayes.
6 ayes, 0 nays. The committee substitute to House Bill 214 will be reported favorably. Senator Hughes moves to be certified for local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 658, sponsored by Hughes. Senator Hughes moves House Bill 658 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio,
Aye.
Nelson, Schwartner, Zaffarini, Hughes, Huffman. 6 ayes.
6 ayes, 0 nays. House Bill 658 will be reported favorably to the full Senate. Senator Hughes moves to be certified for local and uncontested calendar. Chair brings back up House Bill 1151 by Senator sponsored by Betancourt. Senator Hughes moves House Bill 1151 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman. 6 ayes.
6 ayes, 0 nays. House Bill 1151 will be reported favorably to the full Senate. Senator Hughes moves to be certified for local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 1378, sponsored by Senator Hughes. Senator Hughes moves House Bill 1378 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman. 6 ayes.
There being 6 ayes, 0 nays, House Bill 1378 will be reported favorably. Senator Hughes moves to be certified for the local and uncontested calendar without objection. Chair brings back up House Bill 1379, sponsored by Buckingham. Senator Hughes moves House Bill 1379 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman. 8 ayes.
8 ayes, 0 nays. 6 ayes, 0 nays. House Bill 1379 will be reported favorably to the full Senate. Senator Hughes moves to be certified for local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 1661, sponsored by Senator Nichols. Senator Hughes moves House Bill 1661 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman. 6 ayes.
6 ayes, 0 nays. House Bill 1661 will be reported favorably to the full Senate. Senator Hughes moves to be certified for local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 1905, sponsored by Senator Burton. Senator Hughes moves House Bill 1904 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton, Estes, Lucio, Nelson, Schwartner, Zaffarini, Hughes, Huffman. 6 ayes.
6 ayes, 0 nays. House Bill 1904 will be reported favorably to the full Senate. Senator Hughes moves to be certified for the local and uncontested calendar without objection. Chair brings back up House Bill 2015, sponsored by Senator Larry Taylor. Senator Hughes moves House Bill 2015 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 2015 will be reported favorably to the full Senate. Senator Hughes must be certified for the local and uncontested calendar. Chair brings back up House Bill 2121, sponsored by Senator Hughes. Senator Hughes moves that House Bill 2121 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman. 5 ayes, 1 nay.
5 ayes, 1 nay. House Bill 2121 will be reported favorably to the full Senate. Chair brings back up House Bill 2465, sponsored by Senator Buckingham. Senator Hughes moves 2465 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 2465 will be reported favorably to the full Senate. Senator Hughes moves to be certified for the local and uncontested calendar. Chair brings back up the committee substitute to House Bill 2703, sponsored by Senator Uresti. Senator Hughes moves we adopt the committee substitute to House Bill 2703 without objection, so ordered. Now, Senator Hughes moves committee substitute to House Bill 2703 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. Committee substitutes to House Bill 2703 will be reported favorably to the full Senate. Senator Hughes moves to be certified for the local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 2837, sponsored by Senator Hughes. Senator Hughes moves House Bill 2837 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 2837 will be reported favorably to the full Senate. Senator Hughes moves to be certified for the local and uncontested calendar. Chair brings back up House Bill 2886, sponsored by Senator Burton. Senator Hughes moves House Bill 2886 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 2886 will be reported favorably to the full Senate. Senator Hughes moves to be certified for the local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 3055, sponsored by Senator Lucio. Senator Lucio moves House Bill 3055 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
6 ayes, 0 nays. House Bill 3055 will be reported favorably to the full Senate. Senator Lucio moves to be certified for local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 3321 sponsored by Senator Perry. Senator Hughes moves House Bill 3321 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner.
Excuse me.
Zaffarini. Hughes. Huffman. 6 ayes.
6 ayes, 0 nays. House Bill 3321 will be reported favorably to the full Senate. Senator Hughes moves to be certified for the local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 3356, sponsored by Senator Creighton. Senator Creighton moves House Bill 3356 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman. 6 ayes.
6 ayes, 0 nays. House Bill 3356 will be reported favorably to the full Senate. Senator Creighton moves to be certified for the local and uncontested calendar without objection, so ordered. Chair brings back up House Bill 3391, sponsored by Senator Birdwell. Senator Birdwell moves, not here. Senator Estes moves House Bill 3391 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell, Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
Chair brings back up House Bill 3649. Oh, never mind. Oh, we're not calling that one up. Chair brings back up HCR 59, sponsored by Senator Creighton. Senator Creighton moves HCR 59 be reported favorably to the full Senate. Clerk, call the roll.
Birdwell. Creighton. Estes. Lucio.
Aye.
Nelson. Schwartner. Zaffarini. Hughes. Huffman.
Aye.
6 ayes.
Can we amend that as it goes to the floor and ask us to pass the budget also?
I think that's a great idea. 6 ayes, 0 nays. HCR 59 will be reported favorably to the full Senate. We also have motions in writing submitted by Senator Zaffarini, Senator Nelson, Senator Birdwell. None change the outcome of the votes. Without objection, those will be entered into the record. Without, the Senate Committee on State Affairs stands in recess, subject to call of the chair.